comes and how he has to deal with those challenges. There is one case which I'm still handling. That is Golden Jubilee Hotels Private Limited. Friends, it's a 5-star hotel like Grand Hyatt. So you can presume that you are sitting in the same hotel, Golden Jubilee Hotels Private Limited, and it is branded as Hotel Trident. You know, the Trident brand is owned by Agrawal. So in hotel industry, it's a unique case. It's a combination of two entrepreneurs. One is the owner of the real estate, the property, and the other is the operator. You can call it franchisee, but it is also called operator. In Grand Hyatt, where you are sitting right now, I presume, I don't have any idea, I presume that this property belongs to Lulu Group. And it is being run, operated by Grand Hyatt. So the owners of the Grand Hyatt brand, they are operating it. And there are different kinds of agreements for profit sharing or rent, etc. So it's a unique set. Those who have not encountered or audited this kind of hotel business, probably, that's why I would like to go a little bit in depth accountable. You have to take control of the asset. You have to take control of you have to appraise the entire manpower employees. Around 600 employees are working in a 5-star hotel, in any 5-star hotel where 300, 400, 500 rooms are there. Now below 500 to 600 employees will be there. Different kind of employees. So KMP will be, officers or other accounting staff will be around 60 to 70 to 80. Then service staff, etc. So you have to manage them. But you cannot go and manage 600. In normal course also, you are managing, having oversight only on the process owners. Process owners. In the accounts, there may be 20% team. But you are managing one person who is the head of the accounts. And through him, you are having the MIS and managing everybody. Likewise, in a hotel we know there is a general manager, GM, which is called popularly GM, general manager. You will control him. And slowly and gradually you will also look at who is managing the food and beverage, F&B section, who is managing the convention center, etc., who is managing the restaurant or for that matter, vehicles, etc. Because there is in the hotel industry, you can't have the Ola Uber booked. You need to have the best class of the vehicle for your customers, clients. So you need to, once you give your consent to the financial creditor or to the applicant to become the IRP, if the application is admitted, from that day you start your working. So public announcement you need to do immediately within 3 days. I did it the very second day itself because I was ready that yes, and I was keeping track of what is happening. And when I saw that the order is reserved, the order is admitted immediately, I identified that there are 2-3 papers in the area, same area, in the registered office where the major business is there. So as we know, mostly it is there in vernacular and in English newspaper, widely spread newspaper. Power of the board, all the power came to me. So we immediately wrote to the board of directors also that your power is seized, you don't do anything, but your duties are still there. Because you are not seized, it is suspended only. We took the control of the asset. I can't go and put my rubber stamp that yes, it is under control of the Subodh Agrawal. So technically, we put under control. I see that yes, the security is there or not, security is proper or not, whether I require to change the security. So if required, I can change the security, also bring the new security, which is not under the influence of the previous management. I write to all the employees, 600 employees through some communication or email or WhatsApp, whatever. We write to them that yes, it has come under control. You don't be scary. It will be run as a going concern, and you will be getting your salary, etc. Whatever happened previously, because I can't pay the expenses which were due and before CRP period commencement. That you have to file the claim. But from the date of the CRP commencement, you will be getting it all on a priority basis. Immediately, I need to write to the bankers that the signature is to be changed from the old signature. Even if the check was issued 1 month back, the payment cannot be made. If no payment has been made, it needs to be stopped. So all debit entry need to be stopped, and only with my signature it can be done. And intimation to all the GST department, income tax department, that they need to file their claim, and it is under insolvency, and under insolvency, moratorium is there. We know that moratorium under section 14 is there, and that will be there. So MIS, process owner, security, etc. There are prescribed forms that is required to be filed before IIIP, that is the Insolvency Professional Agencies, and before the IBBI. So it's a profession where the compliance is huge, and all deadlines are there. If you forget the deadlines, immediately there will be some penalty, some punishment, etc. also. So you have to be on your toes all the times. So you have to get jotted everything. You cannot be casual. So as a professional, I'm sure we can do that. I'm not going through all the formats or forms that is required to be submitted, but these formats were not there when in 2018, I started my journey as a resolution professional or interim resolution professional of this particular hotel, Golden Jubilee Hotels Private Limited. Now it has come. So I added, just for your information, there are CIRP form which is required to be filed on different events or incident which happens to the IBBI, and there are form 1, 2, 3, 4, like half-yearly form, half-yearly monthly reporting to the IPA. IPA is generally of the issued body. I mean, issued a triple IP of ICAI. So ICAI has a professional agency as IPA. And then the ROC also, you immediately need to file that you have been appointed as RP. The director's power the director has been suspended, the power has been vested on you. So that in INC 28 has to be filed. So henceforth, all the return in the ROC will be filed with RP signature only. Now, if I have to run, I also need to appoint some of the professionals. And IBC allows me, with the concurrence of the COC, to recruit or appoint those professionals. So I appointed process advisor, BOB cap, process advisor. What process advisor do? They see the process. The process is going on. I'm running the process. I'm the owner of the process. But then somebody need to guide to me there, because you know the tender has to come in. I mean, we call it expression of interest. Once that expression of interest has come, then there is one technical document called the tender document, we call it. So here we call it request for resolution plan. RP document has to come in. And then when the tender comes in, that is the bid comes in, there may be more than 1, 2, 3, 4 bids. We need to see that whether it is all legally compliant or not. And now, as you know, the promoters cannot participate. There is one particular section that has been inserted, that is section 29 capital A, that debars the related party from participating in the bid. So whether those party has participated. So for that, we generally appoint process advisor. But those were the initial days. We didn't have the idea. So the process advisor was mandatory. Nowadays, generally we don't appoint, because our team has become so updated that they themselves can take care of. But if it is a big case, it is always advisable not to take risk, because in the bigger cases you get good fee, and the bankers or the lenders or the COC members also go on approving whatever you want. I mean, 10 lakh, 15 lakh rupees per month is not an issue. We appointed, for our process also, we appointed Haribhakti and Company. We appointed two legal advisors. One for NCLT, NCLAT matters, and the other legal advisor, that is the J. Sagar Associates, we appointed only for evaluating the bids, etc. When the bids came in, that time again, that domain knowledge was not there. What should be there in the bid, how it is to be checked. So we appointed the J. Sagar to see the technically. Process advisor, the process-wise, everything is covered, and the J. Sagar as the legal thing. There is a huge scope for forensic audit, transaction audit. For transaction audit, we appointed Khandelwal Jain and Company, a Mumbai-based firm. And valuation is required to be done. Now there is a huge opportunity for valuation also. All of us can become the valuer, and now valuation is required for each and everything. So I will be recommending to our CA brothers and sisters to go for valuation also. It's very easy. I mean, to pass the exam for IBC, to pass the exam for valuation, probably for we professionals is the easiest task. But you need to take a call, what you want to do. I mean, there are huge plethora of opportunities, and it's humanly not possible to go for each and every opportunities. If you are fortunate to have a team, consolidated team of 5, 10, 7 chartered accountants, professionals, then under one banner, if you have all sort of activities, one partner taking care of insolvency, the other for valuation, the other for GST, the other for income tax, then probably you can add a huge value and brand to your firm. So my always suggestion is be specialized. Don't try to be a general physician, as we call. Because I always give the example, if you go to general physician, the fee nowadays has increased to 500 rupees, but if you go to a specialized doctor, it will not be below 2,000 to 3,000 rupees. So a specialized doctor always command better fee and respect. So in case of our profession also, I will recommend that if you are doing your other practice very good, if you want to add insolvency or valuation, please bring in new partners, new team, new verticals, and then only start that. Don't feel that you yourself can, since you are expert in audit and tax, you yourself can do the insolvency also. That will be sometimes it becomes fatal. I'm using the word fatal, and not recommended, at least by me. Now, composition of the COC. Those COC, there were 8 COC members. It is given in the last. And we had total COC meeting of 22. My process went through 10 months. Now you will ask, how it 10 months? Because 6 months is allowed, 180 days. 90 days I got extension, that is 3 months, so 9 months. How it went up to 10 months? Then for 1 month, I got exclusion from NCLT. Since litigations were there, so I filed a petition to get exclusion of 31 days. And NCLT was kind enough to get me exclusion of 31 days. So I got total 10 months. But thereafter, 4 months, 4 years, still it is going on. The financial creditors, the admitted claim was 949. Financial creditor for BG, bank guarantee 20. Operational creditors, claim filed was 242 crore, but we admitted only 102 crore, and we rejected other claim. Operational creditor for employee, 3 crore. Out of 6 crore, we admitted 3 crore, and other stakeholder out of 10 crore, 5.94. So valuation was done. We issued expression of interest. You know, expression of interest is required to be issued within 75 days. So we issued within 75 days. So there is regulation 36 capital A and regulation 36 capital B in CIRP regulation. So now see, if you look at, if you have to file anything to deal with the NCLT, there is rules. So rules provide you how to file and deposit in the, or what are the process for NCLT. But if you have the code, which is technically act, so now if for enabling provisions will be in regulations. So regulations, whenever there is any enabling provision I will be talking, it will be about the regulations only. So we issued the expression of interest, and it was extended also. And finally, we got 10 interest in the expression of interest. 10 participants came forward showing their interest in the property, in the company. the surplus from the NCLT on 7th February 2020. So it took almost 14 months to get approval from NCLT. What is the way out? I don't see any way out. I don't blame judiciary, but then the basic objective of bringing the code was to see that value is maximized, and it is a time-bound process. I completed my process within the time, that is 9 months, and 1 month excluded 10 months, but judiciary took 14 months to approve the plan. Maybe because there were many petitions filed against, maybe more than 40 to 50 petitions filed. Litigations, I'm not going into detail into litigations because it is of no interest. But see, litigation has been filed by the operator, by the operational creditor, by the operator, by the operator, by me against maybe financial creditor. The plan value was 384 crore that go to the stakeholders, 180 crore for capital or working capital expenditure and the working capital. So the total value was 584 crore. During CIRP, when the process, litigations after the petition was filed, and when the petitions was going on, the core hotel had the owners had filed, I had filed, the successful resolution applicant filed, Bank of Baroda filed. Now, what were the challenges faced during the CRP? When I was running the CRP, what was the challenges faced by me? So there were guarantees given to banks, given by banks for some purpose. Now there was no clarity. The bank has given the guarantee, it is not invoked, so it has not materialized. What we call non-funded liability. Now, whether it has to be taken as a liability or it will remain as a contingent liability. That clarity was not there at point of time. Now the IBBI has come out that till the guarantee is invoked, it will not become part of the total claim. So that clarity has recently come, maybe 4-5 months back. Now the operational, the operator that the organized filed the petition in NCLT, that these are two separate entities. One is the operator, hotel owner, the other is operator. The IRP or the RP need to have a control over the owner. It is the CIRP of the owner, not of the operator. So my hotel operation should not be disturbed. There, NCLT said, fine, yes. They directed me that you cannot have control over the operation of the hotel. The hotel will run independently. You only look at the owner. I filed the petition, appeal in NCLT, where NCLT opined and directed no. Both are together because the income of both are coming in owner's account. That's why the RP need to have a control over the operation of the hotel as well as the owner. Now, operational creditors. Now in COC only financial creditors are there. Operational creditor filed the petition that our claim is more than 10%. We should be allowed to participate in COC, have all the papers, have the agenda documents. That was rejected. And there were some disturbance also. Pre-CIRP dues were not paid to vendors. They were coming, doing strikes. We managed. So no major incident happened. So approach to bring efficiencies in completing the process. So we did everything within the prescribed time of the IBBI or IPA. We sent the communication to employees, to the banks, to the directors, wherever it is required, and took control of the asset on the very first day. We had regular dialogue with all the stakeholders, financial creditors, operational creditors, through whatever official channel we had to. We had an excellent team of legal, operation, and compliance expertise. And we had a daily activity tracker. Now, what was in the mind of the Blackstone who bidded, why they thought this property is worth for them. It was a hotel. They were expert in hotel and real estate industry. They had a huge money. Money is not a problem. They were not dependent on any bank finance, etc. But what was the, and why they thought, what they thought that why this company went into insolvency. So their perspective, the Blackstone perspective, who became the successful resolution applicant, reason for company going into insolvency. Because of the second tower, which could not be completed, the cost escalation, the one tower, 323 rooms, though it was generating profit, but since there were loan taken for both the towers, so that tower became unproductive, interests were mounting, costs were escalating, and because of that, they could not pay the interest or loan installment to the banks, and it became NPA sometime in December 2015. And then Bank of Baroda as a lead bank took it to the NCLT in October 2017, admitted in February. Capital expenditure got delayed because of the cost escalation and scarcity of the fund, because of the delay completion. The first tower was scheduled to be completed sometime in 11, which got delayed, could start only in September 2013. Now, what is their perspective? How it can be made successful? They said that because of their experience in hotel industry, in the real estate industry, they can increase the occupancy to make it to 90, 92%, 93%, 94%. And because of occupancy, the food and beverage, which is the major contributor in the EBITDA, will also increase. In hotel industry generally, in food and beverage, the EBITDA comes to around 30 to 40%. And that is major contributor in the bottom line. So here, maybe by giving the hotel room at 4,000 or 5,000 or 6,000 or 7,000, they are not making that much of money. But when we stay here, we have our food, fork out 2,500 for dinner, 300 or 400 for tea. So there they make money. So that way, occupancy will be increased, food and beverage will be increased, and the banquet will be utilized fully. They had already experience of 2 hotels in India and experience in turning around the distressed asset. They had more than 11 million square feet office space in Hyderabad itself. That is 1 crore 10 lakh square feet office in Hyderabad itself, which is given on rent. I mean, they own the office space and give it on rent. So those customers, tenant also, can be influenced or will be lucrated to come to the hotel to stay for their customers or for them also. So that will bring more business. So they have the presence in the hospitality and they have the international experience of having in the hotel industry. So an action plan for building the capability, they said that the second tower, which was primarily for Oberoi brand of hotel and then service apartment, now they said that this apartment can be used for, this space can be used for the office space. For that, appropriate approval from the government authority will be required, and the space rent is around average, on an average 70 rupees per square feet per annum. So that will make profitable. For that, they will be making investment of around 150 to 200 crore, 180 crore for that particular making effective. Now, project execution, they say that project execution is, we have a strong team, so that will not be a problem. We have an expert team for the project execution. Manpower, the required manpower is with them because already they are operating in the same kind of industry. Bid submission and negotiation. We asked them to give clarity. As we said, they've submitted the bid. It's not the easy process. I mean, inviting and getting the bid, thereafter, the legal compliance is a huge burden, I mean, huge task, and the entire accountability is on the resolution professional because he is the primary responsible and he is required to give a certificate for compliance of section 30 subsection 2 and also compliance of section 29 capital A. And there are so many hidden items will be there. You need to go in between the lines. So we asked them clarification on payment to operational creditor. They said that nil payment to operational creditor. We got it minuted. They said, no, we will not pay anything. We got it minuted. That means we raised the question. I mean, equity to all the stakeholders. So we raised the question. It is their wisdom, whether they want to give or not, but we got it recorded, got it minuted in our minutes. There were 2 arbitration proceedings going on. So we said that if it comes in our favor, if the proceeding comes in our favor, who will get the money, whether the stakeholder or you? We got clarification, got it minuted. The TRA account, so there were already 30 crore rupees. So whether you will take all the entire 30 crore rupees or out of this 30 crore will also something will go to the creditors, that is the banks. They agreed that beyond 16 crore, the excess beyond 16 crore will go to the bankers. So up to 16 crore or below 16 crore will remain with the investor, and the other excess will go to the bankers. And all the expenses post CRP will be borne by them only. Source of fund they all brought in, because source of fund was not a problem. There was major hurdle was land transfer from the government department. So that also, but they put a condition on that. That is the reason that since 4 years it is still going on. Counter bank guarantee against the 20 crore guarantee, that was there. And then timelines, etc., it was there. Challenges in the implementation. The plan got approved, but the challenges was in implementation, because as I said, there was a condition precedent. The land was to be transferred from YATC, the government department, youth affairs department, etc., to the investor. That due to COVID, no meeting could be held. It was to be done within 1 year. Within 1 year, it could not be held, and then the investor backed out. They said that the time was given 1 year. They waited for 16 or 17 months, and within 16, 17 months, it could not be done. So we are backing out. Friends, they backed out. They said that they gave us a letter that we are backing out. What we did, we had a bank guarantee of 30 crore rupees. They had given a bid bond and performance bank guarantee of 30 crore. The moment they said that we are backing out, we invoked the bank guarantee. We got 30 crore rupees. Now, it's a 400 crore deal. Only 30 crore we got. So, whether the banker will leave them to go out? No. We filed a petition in NCLT that they cannot go out. Now, there is a Supreme Court judgment, recent judgment, in IBIX, that once the plan is approved by COC, the applicant cannot back out. They have differentiated between IBC and Contract Act. They say that in IBIX judgment, I'll request all of you, it is a very important judgment. I didn't have the time, otherwise I would have shared that judgment to all of you. That IBIX judgment says that IBC is a special statute. And this being a special statute, if you apply Contract Act provision in IBC, it will not work. Only where specifically said, there only the other statute will be coming and interfering with the IBC. Otherwise, IBC is a expressway. It will go on its own way. Nobody will come from outside and disturb it. That's why it is called code. Why, you know why it is called code? Why not act? It is called code because it's an expressway. 11 statutes were changed, 11 acts were changed to make it, and there is a non-obstante clause, section 238 in the IBC, which says that it is a superpower act. Now, we got this stay, and there were plethora of cases has been filed in Telangana High Court, in NCLT, in NCLT, in lower courts. Now, due to COVID, nothing is moving. My dear friends, my plan got approved in 7th February 2020. From 23rd, 24th, 25th March 20, the Corona closure started, everything is stopped, and the court also working is not up to mark. So we, in spite of our pursuing a different fora, we have not been able to take up very aggressively. Recently, these are the lenders, the COC members, and recently these were the resolution applicant. Friends, recently we have decided that we must approach Honorable Supreme Court to give the direction that all the cases that has been filed at different fora should be brought together at one place and addressed. Otherwise, IBC will lose its scene. IBC will lose its charm. That's all what I wanted to share with all of you on the corporate insolvency resolution process of Golden Jubilee Hotels Private Limited, which is still very doing brisk business. In today time also, if we are having a occupancy of 55%, probably it is one of the best occupied hotel in the IT city of Hyderabad. If you happens to go to those sites, you can have a look at it. Since my time is over, it is already, I have surpassed 10 minutes. I'm 10 minutes over what was the allocated time to me up to 11 o'clock. It will be my pleasure to share, give any response or reply to your query if you have any, on any topic, related to IBC. It will be my pleasure to respond to that. Over to you. Thank you. Thank you very much. Or if no one is there, if you want, I can just run through the my presentation on Supreme Court judgments. If you want, I can run through the Supreme Court judgment, at least IBIC's judgment. No, it is not my. So my presentation is over. So I'm only trying to utilize the spare time if you have. Otherwise, my presentation is over. The one PPT I have done away. Yeah, questions, probably there is no questions. Probably my presentation was fantastic. So that's why there is no question. So I will up to mark. No, I always take it like that only. See, judiciary, Supreme Court has said in innovative industries, please stop me wherever you feel, you can stop me. IBC is an exhaustive code and is complete in itself. This is the first Supreme Court judgment in respect of the IBC. The second was Swiss Re1. Again, the comment of Rohinton Nariman was, see the comment, in Swiss Re1 Private Limited case, defaulter's paradise is lost. With the introduction of IBC, defaulter's paradise is lost and the constitutional validity was upheld. Now, repugnancy of the state law, it's very technical, I would not like to go. It overrides all other act, income tax, law of limitations. This is one again very important judgment. Why each one of you need to understand IBC? You are auditing. In the balance sheet, your client has both debtors as well as creditors. It is your duty to alert your clients as an advisor, not as an auditor, that if there are creditors and the payments has not been made, the creditor can at any point of time, if the amount outstanding is more than threshold, for start of the insolvency, and you will find that your promoter, the promoter has been overtaken by the RP. So creditor, if more than 1 crore, you need to see that payment has been made or not. If payment is not made, whether the dispute has been created. Likewise, in case of the debtors, receivables are there. If it is more than 1 crore rupees, if payments are not coming, you can advise your client to file the insolvency petition. So that also, there also then only client will feel that yes, we are putting value addition. Now, limitation is applicable, law of limitations. In insolvency, it says that it is not suit, it is application. You say that application under section 7 or 9 or 10 in NCLT. So Limitation Act, Article 137 will be applicable. And what Article 137 says about the time period? 3 years. So limitation of 3 years is there. So when we used to do our audit and used to go to the bank branch audit, we used to see that there is blank acknowledgement. Documents are kept in the file of the customers. We used to say, why this blank? Because of the limitation. Every year, they used to keep the blank, fill it up, and put it, that acknowledgement is there. That means a limitation is extended. So to get the limitation of 3 years extended, you need the acknowledgement signed. Now, if you don't have the acknowledgement, and the debt is due for more than 3 years, can you file the petition under IBC? No. Sorry, you can't file. So you need acknowledgement. What do you mean by acknowledgement? Written document from the borrower or from the debtors to the creditor. If it is not there, then there was a recent Supreme Court judgment in Bisal Jaiswal, that even if your name is appearing in the financial statement, it will be treated as acknowledgement. Previously, NCLT with 5-member bench, judge bench, with majority said that no, entry in the financial statement will not be treated as an acknowledgement because it is by force of the law. Supreme Court said they reversed the judgment of 5-member bench judge, which was done with majority, that if there is an entry in the balance sheet, in the financial statement, without any caveat, it will be taken as an acknowledgement. And date of signing of the financial statement will be treated as date of acknowledgement. And then the 3 years acknowledgement will start from that date. Now, I will give an example. I had given a loan in 2011. I didn't have any acknowledgement. Now, in 2018, I got an acknowledgement from the party, and I want to file today in 2020. Say 2019, I got the acknowledgement, and I want to file the application case in 2022. Can I file? 2011, I gave a loan. I did not have any acknowledgement. I got the acknowledgement only in 2019. Today is 2022, less than 3 years. Can I file the claim? Can I file the petition? No. Why no? Your answer, you will be wondering that from 2019 to 2022, it is less than 3 years. So it can be filed because the acknowledgement is there. No. Dear friends, acknowledgement has to continue before the expiry of the previous acknowledgement. So my previous 2011 should have been renewed by acknowledgement before 2014, which is not there. So once acknowledgement, that limitation period is gone, it cannot be revived. So I should have acknowledgement either every year or before expiry of 3 years, so that I could have filed now also. So 2014, 2017, 2019, then I could have safely filed. Even if it is a loan of 2011, I could have filed the petition in NCLT. So that is the law of limitation. Now, one best thing in insolvency. Previously, when you used to buy a company, you used to ask the consultant, Baba, please do due diligence. I want to buy this company. What is the liability? What is the tax liability or hidden or unhidden liability? If you buy a company through insolvency process, you don't have to bother anything. Don't have to bother anything. You just value that this company is worth 200 crore. Though the outstanding may be 2,000 crore or maybe outstanding maybe 1,000 crore or 500 crore, you don't bother. How much you want to pay? 200 crore? You don't bother what are the liability. In the plan, you will mention that 200 crore rupees. Now, whatever liability, there will be income tax liability of 500 crore, there will be GST liability of 200 crore, there will be TDS liability of whatever amount, there will be provident fund default, there will be gratuity default. You don't have to bother. The new investor don't have to bother. The successful resolution applicant don't have to bother. The moment you pay 200 crore rupees, you will get the debt-free company, no liability. The liability up to CRP commencement debt is freezed. In Supreme Court, an SR Steel case had mentioned, they had used a very unique language that if the liability is allowed, it will tantamount to Hydra head propping up. And that was more beautifully clarified in case of Ghanshyam Das Misra. Recent judgment of the Supreme Court in Ghanshyam Das Misra, where it said that the new investor should start with a fresh slate. If he has quoted 200 crore rupees, there is liability, or somebody has not filed the claim. It does not matter whether you filed or not filed. Claim is freezed. Liability is freezed. Only 200 rupees will be distributed and the investor will get the company all free. All PMLA cases, all. It will go with the old promoters. Section 32 capital A has been introduced. So the new investor is protected from all old baggage of dirtiness. Cancellation of contract can, in the guise of insolvency, I can cancel the old contracts, which is not beneficial to me. Just remember, in Abex case, I had said, Supreme Court told that Contract Act is not applicable because it's a unique case. Here I'm saying that no, Contract Act will be applicable the moment you talk about cancellation of the contract. Unless and until this contract is related to CRP process. Like in case of Urja Vikas Nigam, there was a power purchase agreement. And in the agreement, it mentioned that if any of the company goes into insolvency, the contract will be cancelled. So I am selling the power. The buyer company, they had contracted at 8 rupees per unit. The buyer company, the market rate is now 3 rupees. It became unprofitable because since the contract was there, the moment I went into insolvency, they invoked the clause. That since the agreement says that if the contract can be cancelled if any of the company goes into insolvency. They invoke that. Supreme Court said no. What is the objective of the IBC? Objective of the IBC is to keep on the company as a going concern. If the contract is cancelled, the company will immediately go into liquidation. Because what is the product? The only product is power. And the power purchase agreement is there. And if you cancel the agreement, the company existence will be in question. So it's matter related to CRP, and that's why the Contract Act will come into force. So contract which is directly related to CRB cannot be cancelled, other can be cancelled, and in other cases, the Contract Act will be applicable. Related parties, if there is a malfeasance, fraud, corporate veil will be pierced. Insolvency of, if the guarantee was given by the company, but for the loan taken by the individual or proprietorship firm or partnership firm, it says that who had given the guarantee? Corporate debtor, company. So against company, the insolvency will start. Resolution plan cannot be withdrawn. EBIC's judgment, I talked about that. Contract Act, unless and until specifically mentioned, will not be applicable. So resolution plan once submitted, as per the Contract Act, says that unless and until the contract is accepted, it can be withdrawn at any point of time. But the judgment said then there will be no point of having the act. Then anybody will file the plan today, and tomorrow they will try to withdraw the plan. And Leo edible oil, that's a High Court judgment, only the last slide, that if any attachment was made by the Income Tax Authority, it's a Telangana High Court judgment and a landmark judgment, first of its kind. Attachment was made prior to CRP commencement. When liquidation started, liquidator went to sell the asset. Income Tax Department said, no, it cannot be sold because we have the attachment, and the attachment was made before the CRP commencement. Telangana High Court then quoted Section 14 and Section 238, non-obstante clause, that IBC is the super boss act. It supersedes the other act wherever there is repugnancy. So to understand repugnancy, you need to read the Supreme Court judgment in Innovative Industries and Article 254 of the Constitution of India. Friends, again, with regard to case laws, very briefly, I touched upon. Thank you very much.
Maybe with a big round of applause, we could thank our Honorable Past President, Subodh Kumar Agrawal ji, for a fine session, sir. Wholeheartedly thanking you, sir. Let me invite and request CFO of Lulu Group India, CA Satish Kurup, sir, to kindly present a memento as a token of our gratitude to Subodh, sir.
So you are the owner of this hotel.
May I now invite and request Sri Rajagopal Kamatji, Senior Manager from LIC, who handles group insurances and policies. We would like to hear from him and probably enrich ourselves more on the group insurance factors and the other various opportunities for us. And inviting Rajagopal Kamatji. We are indeed very grateful to LIC for the proud support that they've given us for the great conduct of this conference. Once again, wholeheartedly thanking and welcoming Rajagopal.
Don't mind me wearing mask. Okay. No percentage. How many minutes I have? See, I'll brief about LIC. They have asked me to. And also, I'll clear. Okay. Good morning, all. So, kindly pardon me for wearing the mask. Twice COVIDed. Now, third time I don't want to get affected by Omicron.
First of all, let me thank Institute of Chartered Accountants of India for this wonderful opportunity to address this intelligentsia. Actually, I was waiting for a chance to talk to you regarding the beneficial schemes which LIC has put forward, which is successfully functioning and showing consistent performance for the last several decades. As you know, LIC has been in operation for the last 65 years, successful operation. It is one of the mightiest organizations in the world, in India too, with a staggering fund size of 38.5 lakh crores. We are now second to anyone in India, largest in Asia, and of course, as Life Insurance Corporation, as an insurance company, our claim for performance, which matters most, is over 99%. So I'm proud to be associated with the organization, and also I'm happy to inform you that some of your esteemed members are our employees. They are here. So hello, everybody. I'll just briefly mention about the performance of LIC of India, which you will be interested to hear. As you know, it's a national organization. Before that, entering into that, I request you to use the LIC India website. We are all policyholders of LIC of India. It is licindia.in. Register your policies in that portal. And I will not talk much about the IPO, which will be for a few weeks from now. So if you are interested, you can open a demat account. LIC has been advertising about that. So some preference will be given to our policyholders, esteemed policyholders in that IPO. That's the information which we are getting now, and that's what we are advertising now. So LIC of India started operation in 1956 by merging around 256 private insurance companies. Our initial contribution from the government was 5 crores. From that, we have reached a life fund size of 38.5 lakh crores. Now, our number of policyholders is around 32 crores. Even though it's 32 crores, this large country with 140 crore population, there is still a long way to go. We are everywhere in the nook and corner of the country with 2,048 branch offices and over 1,500 satellite offices, and so many mini offices, and also premium collection points. And of course, we have pension and group schemes departments, which I work. Around 69 units are there all over India, which is very relevant to your area of activity. And the performance, almost, it comes to around over 5 lakh crores per year. Last year also it crossed 5 lakh crores, new business premium. And total premium was over 6 lakh crores. And for your information, our daily collection goes to around 2,000 crores. It is invested on a daily basis. We have a very good investment department for conventional schemes as well as our group schemes. Our group scheme portfolio is around 10 lakh crores as on date. So it's a huge financial institution. We cater to the needs of the government also. As you know, it's people's money we use for people's welfare. We continuously contribute to the 5-year plans. Mostly our investments are in secure corporate, the government securities, central government securities, and also state government securities. And housing, power, ports, roads, bridges, etc. We fund maximum. The total fund invested in these sectors for infrastructure building comes to around 27 lakh crores. Balance we invest in so many other statutory investments, and only a few percentage is given to the equity market. But still, we are a major player in the equity market, as you know. I can proudly say that almost we control the equity market. Our investments are mostly in blue chip and high-yielding instruments and investments. We have 5 divisions in Kerala. It's a national seminar, but still I'll tell you it's most relevant. 5 divisions in Kerala. Here it is Ernakulam division. There is Thrissur, Kozhikode, Kottayam, and Trivandrum. Our employee size all over India is around above 1 lakh. And our gems of LIC of India, the aggressive marketing people, there are 1.3 million agents. So it's a huge organization with international operations also we have. We have branch offices in Fiji and Mauritius, Bahrain. And we have joint ventures in 4 or 5 countries. And we have wholly owned venture in LIC Singapore also. There is LIC Lanka, Nepal and all. So we have, our group has mutual fund, LIC Housing Finance, LIC Mutual Fund and LIC Housing Finance, and recent entrant is LIC Pension Fund. So we have reached everywhere, every area of financial this thing, and including the recent entrant with 49.24% stake, we have entered the banking sector also. We are a major player in banking with IDB Bank with us now. Regarding the policies, as you know, most of you have subscribed, our major plan, I'm not going to name the plans. There are broad plans with endowment, money back, single premium endowment plan, annuity plans, cover again, plans that cover diseases, children's plan, etc. So this covers most of the population here, and mostly the objective is to spread the message of life insurance among the public, especially into rural population. I can proudly tell that we are the only organization which concentrates in rural population. As you know, we are a profit-making organization, but profit is not the only motto of LIC of India. We are also concentrating on social welfare. Our Pradhan Mantri Vayavandhan Yojana is doing exceptionally well, and our pension and group schemes department handles the Pradhan Mantri Jeevan Jyoti Bima Yojana. Our associates are most of the banks, cooperative banks, who contribute to this social security scheme. And which is most relevant to you, I'll come to that. Our pension and group schemes department handles the beneficial fund management schemes, such as the group gratuity cash accumulation scheme, group leave encashment scheme, group superannuation scheme, group's term assurance scheme. As you know, as a statutory requirement, Gratuity Act 1972, the corporates which are having 10 or more employees should pay gratuity to their employees, 15-day salary for each year of continuous service after 5 years. So the government has given an opportunity to the corporates to fund with insurers like LIC. So we have formulated a scheme, it is group gratuity scheme. Proudly I can tell, we have a market share of around 98% in this area for this gratuity scheme. And in Kerala, our market share is more than 96% in gratuity scheme. As you know, in all over in this state, I have worked in all divisions in Kerala, almost all the corporates, most of you must be knowing, some of the faces are familiar. They have subscribed the gratuity schemes, and the major banks, major players, major corporates, porters, shipyard, Federal Bank, South Indian Bank, BPCL, just name the company, they are our client. They have subscribed the gratuity scheme. And fund size all over India soars to around 8 lakh crores for gratuity. That is invested separately. And the benefit is divided among the policyholders. It is not a separate investment, it is a pooled investment which goes to the gratuity. As you know, as per the accounting standards, AS15, we conduct the actuarial valuation for the benefit of the company, and mid-term valuation also we used to do as per the requirement. Annual fund statement we give, and we ensure that the administration of these schemes are hassle-free for the company. I think the small corporates may not be having the infrastructure to go through all these formalities. So we help them with all the required forms and formalities and guide them to get the benefit. As you know, the gratuity funding is treated as business expenses. So above 5 crores, they may get up to 40% per year, the contribution which is made to the gratuity trust. A trust is to be formed to implement the gratuity scheme. So around 40% benefit is substantial. So I request you people to, our esteemed members, to tell your associates to subscribe to this gratuity scheme. And also the group leave encashment scheme, Now it's getting, it's in vogue now. So many of the corporates have subscribed that. It's not clear whether the IT benefit is given or not, but still most of the companies who have subscribed to this benefit are getting the tax benefit. It just goes on like the gratuity scheme where we conduct an actuarial evaluation based on the assumptions of your performance, whatever you give us, the employee data and salary escalation. We advise a funding to the customer and they can fund it incrementally. And for gratuity scheme, I would like to remind that the corporate can fund in 5 easy annual installments. A leave encashment scheme also, they can fund in convenient installments. These both work as cash accumulation schemes, and annual funding is being done. As an insurer, we are a fund manager plus an insurer. A small insurance is provided with group leave encashment scheme, but the main feature of the group gratuity scheme is that future service gratuity is covered for the employees. Suppose if something happens to the employee in between in service, his future service gratuity is assured. The only damage to the company is the risk premium which is given for that future service gratuity. As you know, the gratuity limit is 20 lakhs. Whatever the balance amount from the date of the unfortunate event to the retirement date is given as a risk cover. So that is in HR perspective also, it is a wonderful scheme. So please tell your associates and your clients to subscribe to the scheme if they have not already subscribed. And also there are other schemes like group leave encashment scheme for you to subscribe. Another major important thing is that we see that people are living longer. Anyway, as an insurer, we are happy because people are not, the claims are not much. So one thing is that we retire at 60 years of age, not you. Employees like us retire at 60 years of age. And they are living up to 80, 90, 95, because I am seeing annuitants who are coming to our office, 93-year-old annuitant, 95-year-old annuitant, and we were servicing an annuitant who is 103 years old, who owns a large corporate, now he is no more. And another, our reputed customer from Malappuram, he was also above 100 years old. So people are living longer. There are young, old. So now they're getting old. Now you have to wait up to 80 years of age. What I'm trying to tell is, pension scheme is most relevant now. There should be a pension scheme. We are all having pension scheme as employees. We are secured by some pension scheme. At least it will give us some benefit. The workers in corporates, the people in associations, reputed associations like you, they should have a pension scheme. They should have some benefit, monthly benefit, when they reach the older age. We don't know, we may live up to 80, 90 or 100, we may all live, because even in that pandemic stage, the death rate is very low in India. In Kerala, you see the death rate is very low. So it is unbelievable as far as the international scenario is concerned. So we are getting healthier and healthier. That shows that we are going to live longer. We should have a regular income. LIC is having annuity schemes. It is not a Jeevan Akshay. It's a wonderful scheme. We shell out some good purchase price initially. We are assured of a return for our lifetime. Different type of annuity schemes are there. And inflation-linked annuities also we are planning to introduce. But still, in the younger ages, we should advise the employees of the corporates to invest in pension schemes so that they get at least some benefit at the time of retirement for their future lifetime. Think of a situation where an employee who is a member of a large corporate having nothing after 5 years of retirement. Whatever he is getting from PF department and the gratuity will go for purchase or giving to their children or purchase a flat or land or whatever it may be. They are left with nothing. Most of them are subscribers of PF department, PF pension scheme. As you know, how much they will get from the PF pension scheme. So some amount, we have to take it seriously. Today, I want to give a message. This pension scheme is most relevant to you. As I told, we are secure with pension scheme, but that also is not that secure. We don't know how the inflation is going to be after 5 years, 10 years, 15 years. The medical expenses are soaring high. So at least we should have some relief from our pension scheme, annuity scheme. Whatever the benefit which we get monthly, a small amount, a sizable amount should be kept aside for the future retirement benefit. As you know, please think of a scenario where you are living up to 80, 90, and keep aside that money today. If you have not started, please start today. Please advise your clients to start today. We have wonderful schemes. We have group superannuation scheme. There also the corporate will get tax benefit. We have defined contribution scheme and defined benefit scheme. Defined contribution scheme means the contribution is defined. A percentage of the salary from the employees is kept aside for the pension scheme, which is invested in LIC's group superannuation scheme. It is an individual investment scheme. The individual investment will get the tax benefit. Another benefit is there. The corporate can also invest in that up to the tune of 27%, including the provident fund contribution. Maximum contribution allowed with provident fund and superannuation contribution for the corporate for getting tax benefit is 27%. So they are also benefited. It is treated as business expenses, 40% benefit is there straight away. And in HR perspective also, people are going to stick on to the company. After this pandemic, I'm seeing that most of them are not leaving. Even though there is mass resignation in US and all, there is no mass resignation here. Everybody is sticking on to their company. Whatever the benefit they are sticking on to the company. They are not resigning. They are working from home or from office. They are happy with what they get. Now we have to take it seriously. For the superannuation scheme, pension scheme, we have to take it seriously because it is another reason for them to stay with the company. Superannuation scheme, this contributory superannuation scheme, they can also shell out 10-15% to the scheme where they get tax benefit. These IT firms, new gen firms, everywhere this can be implemented. Even small firms, only 10 people are needed to start the scheme. Second one is defined benefit scheme. Defined benefit schemes is slightly costly because we conduct an actuarial evaluation immediately and we'll define the pension at the first instance itself. We will say 50% of the salary, last drawn salary will be given as pension. That means it will be a huge amount. The company has to shell out huge amount. Our corporates have to grow to that extent where we will be able to give them a defined benefit pension scheme. Just think of a situation where an inflation-linked pension could be provided to the corporate, an employee at the time of retirement. How loyal he will be to the corporate or she will be to the corporate. In that way, we have to mold the corporate. Now, after 60 years of age, 58 of age, they are left out. Either defined contribution, now as you know, after 2014, the defined benefit schemes for the central government and other public sector it's not there now. Now they have defined contribution scheme, a percentage is from the employee and a percentage from the companies invested in defined contribution pension scheme. Now NPS is also there. It's all equity linked, unit linked. I'm not telling anything about NPS because we are also a fund manager for NPS. But still, as an aggressive marketer, I can say that the scheme with pension and group schemes department, the group superannuation scheme is the best in India. Yeah. So I'll take 2 more minutes. So friends, my esteemed members of ICAI, I request you to tell your associate corporates to subscribe to these schemes, mostly the superannuation scheme. If there is gratuity, it's okay. Tell them to subscribe, leave encashment scheme, plus this group superannuation. I know now you are aware how relevant it is. So about some of the alternate channels which we are operating. I'll just finish with that. We have bank assurance, which we sell insurance through banks. And we have micro insurance, which we sell micro insurance through our associates. And we have introduced the Chief Life Insurance Advisor channel, where agents are allowed to recruit agents. As an HR perspective, we have senior business associates where our high-performing development officers are given special benefits. And those development officers, high-performing development officers going out, are working with us as LIC associates with special benefits. We have a health insurance department. So it is injustice if I am not talking about this, because I am talking about LIC of India. I was talking only about pension and group schemes department. So that's why I'm mentioning other alternate channels also. We have a health insurance department with coverage for diseases also. There is a successful policy called cancer cover, which is doing well. As I said earlier, our claim settlement ratio is 99%. We have very good CRM initiatives. Policyholders' grievances are handled there. So people can advise them to approach there. There are no grievances with pension and group scheme department. And other also, since it's a large with 32 crore population, policyholders population, some grievances will be there. We are handling it successfully. So any one or two questions? Any one or two questions? I'll give, he has given me some time to. Any questions you can ask regarding LIC of India? Nothing about IPO. I'm not supposed to talk about IPO. Group schemes, gratuity, superannuation, leave encashment? Nothing. Okay, friends. Thanks a lot for this opportunity. Thank you.
Thank you, Shri Rajgopal Kamath, for enlightening all of us on various schemes, various policies under LIC, probably something that we could all advise to our clients, or rather also have it in our effective use for our staff or office members. So once again, wholeheartedly thanking LIC Group for the great support that they've given for the conference as well. On behalf of each one of you, I present a memento as a token of our gratitude.
Thank you. Thanks a lot.
Next, I'm sure we are all eagerly waiting to hear from our star, Jatin Christopher, sir, somebody who's truly been a great brother for Ernakulam branch, a single phone call away that he is available for all of us, and thorough and regular speaker at Ernakulam branch, a dear good friend of all of us, wholeheartedly welcoming Jatin Christopher, sir, for the next session. As he has rightly coined the topic, GST way ahead for